Hello, everybody. We are back again today to finish what we started on reading this enormous document from yesterday. We started it. It was filed on August 26th. So just bear with me. I'm just going to pull up my chat here so that I can actually see what y'all are saying, and we will just jump right in. Okay, so yesterday, where we left off was on this page here, page 16, and Christopher Melcher, the attorney for USA Today, he actually filed this with the court, and he was making his argument on the point that the remote should be reinstated in the California courts. And his argument was the reason for that is because it's actually like unconstitutional. The public has a right to see what's going on in our institutions, and especially during something like a pandemic where it could be harder for people to go and see that court proceeding for any number of reasons. We should really be able to see and hear what's going on in our institutions. Hey, everyone. Hey. Thank you for coming back. So yesterday, this is where we had left off. Our good friend Christopher, probate conservatorships are governed by the rules of civil actions, and there is no statute that would authorize the closure of those proceedings. Now, we did read through this whole section already, so I'm not trying to get too in the weeds on that. I think that we stopped here, though, right? Did we? Any closure? Yeah, we had stopped here. So this is his second argument, and he's saying any closure of probate proceedings other than for confidential matters, and that would be, oh, thank you so much, Pieces of Me. Oh, MVP. Oh, you're so nice. Oh, so generous. Thank you. Yes, hashtag Free Britney. If I wasn't doing this today, let me just adjust this. If I wasn't doing this live today, I would be doing another live because the Department of Justice just denied an elder abuse nonprofit's request to investigate Britney's case. And I really want to read through their complaint, and then I also want to read the denial of investigation, but we'll have to fully what exactly Chris's argument is. He says the California Supreme Court, in this case he already cited before, NBC subsidiary, mentioned a probate case to illustrate the utility of keeping court proceedings open to the public. And then here's an excerpt from it. In this other case, the public has a legitimate interest in access to court documents. Thank you. We should not have to be buying them. I literally paid like close to $43 just for this document. Like, we shouldn't have to purchase. That should not cost that much. That should not cost that much. And I've often thought that it was unconstitutional. So I'm glad I'm reading it here. If public court business is conducted in, they're citing it. See how it's like in these blocks here? That means it's cited from another case, and it's cited from this case right here, NBC subsidiary. So this is the quote. It's coming from that case, and Christopher is using it to help his point along. And what do they say there? As observed in that case, the public has a legitimate interest in access to court documents. If public court business is conducted in private, it becomes impossible to expose corruption, incompetence, inefficiency, prejudice, and favoritism. I agree. In Ray, The Estate of Hearst, 1977. For this reason, traditional Anglo-American jurisprudence distrusts secrecy. Well, that's the first thing me and traditional American jurisprudence have had in common in a while. Distrusts secrecy in judicial proceedings and favors a policy of maximum public access to proceedings and records of judicial tribunals. Okay, so basically, he's just using this as support for his case. Oh, thank you so much, Artem, for the 9 SEKs and the very cute emoji that is drooling. That's my reaction routinely to reading some of these things. Oh, thank you so much. Okay, so the estate, so basically he's just using precedent. These are cases that the court's already been decided in court, right? So it's really easy to rely on those cases that have already been decided because it's already been decided, right? Okay, so then he goes on to say the estate of William Randolph Hearst was a matter of public concern, which the trustees wanted to keep private and obtained sealing orders from the probate court. A media outlet successfully challenged the order. Okay, good. This is good. This is lining up with our case so far. Oh, Swedish crowns. Oh, thank you for the crowns. Oh, that's so nice. Thank you, Artem. I don't know if I'm saying your name right. In considering, okay, so a media outlet in this case challenged successfully, right? So he's trying to say, look, they did it in this case, so you should do it on Brittany's case too, and you should decide in my favor. He says they weighed the privacy concerns of the estate versus the public interest. So they did a balancing test, is what you're going to be told that's called in law school. Here's the quote. In considering the reasonableness of the various orders of the court, we point out first that no statute exempts probate files from the status of public records. Thank you. Because this happens all over the country and probably the world. For some reason, people think when you're talking about somebody's estate, all of a sudden it's private. No, you got the courts involved, you got the government involved, and guess what? That's public. It's just public. It's not, it's just is. I don't understand why people think they get some type of special treatment. Like they want to use the sword of the court, but they don't want to like have to sort of have it used back against them. That is when individuals employ the public powers of state courts to accomplish private ends. Ooh, we're going to highlight that. That's what, I'm not going to mention any names, but I'm sure y'all know who is doing. Such as the establishment and supervision of long-term testamentary trust. They do so in full knowledge of the possibility, disadvantageous circumstance. Oh, I'm sorry. They do so in the possibly disadvantageous circumstance that the documents and records filled in the trust will be open to the public. Okay. I'm going to start this over because I know I stopped a few times. So this is the quote he said. In considering whether it's reasonable, right, the various orders of court, we point out first, no statute exempts the probate files from being public records. They are public records. And when individuals employ the public powers of the state courts to accomplish their own private ends, like theft or conversion, or the establishment and supervision of a long-term testamentary trust, they do so in full knowledge of the possibility, basically, that that's going to be public. And that's exactly what I just said. You cannot use the court as your own shield and then use it as a sword to keep it private from other people. You brought it into court. It's called open court for a reason. Okay, so now he's quoting another case. Yes, Team Marshall, I was just talking about the DOJ case. I will be discussing it at some point, yes. Okay. So he's quoting another case called Shepard versus Maxwell, and he says, apologies. So this is actually still a full quote from this case up here, the NBC case. So Christopher is trying to use the court's reasoning from the NBC subsidiary case in order to say, look, that's what's happening in our case. So in that NBC case, they did this part here, and that's what we're about to read. They said, the court stated it is a vital function of the press and criticism. Well, guess what? Just call us the press over here at ThatSurpriseWitness Enterprises. Function of the press is to subject judges and courts to, quote, extensive public scrutiny and criticism. The Hearst Court quoted an early California Supreme Court holding, and in that holding it said, people have the right to know what is done in their courts. It's such common sense. It's really just common sense. The Hearst Court concluded, unless there's some strong reason otherwise, the public has a legitimate interest and right in the general access to court records, one of special importance, when probate involves a large estate with ongoing long-term trusts, with reputedly, I don't know what that word is, administer and control a major publishing empire. Oh my gosh, this is such a good, I know I'm highlighting everything on this page, but listen, it says the public has a legitimate interest in these court documents. We have to be able to have general access here. And it's especially important when when probate involves a huge estate with a huge trust that's in control of a major publishing empire. Well, that's exactly what we have going on here. That's exactly what we have going on here in Brittany's case. So this is a good case to use. There's strong interest in public trials because it provides an opportunity for spectators to observe the judicial system, improve the quality of testimony, encourage witnesses to offer testimony, and prompt judges, attorneys, witnesses, and jurors to perform their duties conscientiously. So basically, it makes for more accountability on the courts. Everything is just better whenever people don't know. I mean, listen, I've worked at jobs where I wasn't being surveilled with a camera, and I've worked at jobs where I was. And I'm going to tell you one thing. I was a lot on my more best behavior whenever there was a camera watching me. Now, does that mean that I endorse and encourage watching your workers on cameras? No, I do not. That is not what I am saying. However, there is a psychological component here to a judge who knows they're going to be watched and scrutinized. They might be more willing to go ahead and do what's right and do what's going to hold up under the color of law. Versus if they're not being watched, if nobody's looking at them, they might just do whatever they want to do because there's no really accountability latch there, right? So Christopher's saying there's a strong interest in public trials because it provides for that accountability. He goes on to say the Hearst court noted that discretion existed for temporary denial of access to certain records, right? And that might be appropriate in some cases, and that would be highly unusual, okay? Not every wealthy family becomes the unfortunate target of a series of this kind of attacks. I don't know if I'm allowed to say that word here on the YouTube. If indeed it were established that beneficiaries of these trusts, in this case that he's quoting from, would be placed in serious danger or loss of life or property. Okay, listen, this is the standard. Serious danger of loss of life or property as a consequence of the general public having access, right? This is the standard. Oh, hi from Nova Scotia. Hi, Melissa. Access to the Hearst. Okay, then the court, if there was a serious danger of loss of life or property, right? That's a really high standard, okay? Then the court would have the power to protect those interests by temporarily. Ooh, I hope Chris is gearing up to argue that we should have open files to all of the files. Ooh. Denying public access to those files in that protection of beneficiaries is one of the justifications for court jurisdiction over a testamentary trust. Close and difficult factual questions may be involved in balancing the right of the public access to to those records, to the, in this case they were talking about some type of a tax. We don't know what the judge is going to say in Brittany's case. We really don't know what is going on behind the scenes. Everything's been closed, so we don't know. I don't think it has anything to do with these attacks, but who knows, it could. So basically, just to sum up that second argument here, he's basically saying there's a certain standard that has to be met here for you to close the courtroom, and that standard is serious danger of loss of life or property as a consequence. Okay, so Christopher's saying, you don't meet that standard here, Judge Penny. And if you do, well, we need to know about it as the public because we have a right to these hearings. Then he goes on to number 3. Case law for LPS Act conservatorships is inapplicable. So he says proceedings under the Lanterman-Petrus-Short Act, that LPS Act is what they call it, are different. A statute makes those proceedings non-public. This is so funny. So I have talked about this a couple of times, but Brittany is under a probate conservatorship. She's not under an LPS conservatorship, but a lot of times Gerald and Geraldine like to use case law from the LPS conservatorships. Interestingly, LPS conservatorships are for people with mental health conditions. It's a mental health conservatorship is what it's called often. And California is perhaps the only state in the whole union that does this. Maybe a couple others do it. But essentially, it's basically like a conservatorship that's supposed to be like more protective of the conservatee, because what it does is it kind of says, look, whatever's going on right now may be temporary. So you have to each year check back in with us. You know, there's a lot more stuff you have to do. You can get away with a lot more in these probate conservatorships if you're a bad actor. So wouldn't you know that Brittany is in one of those types, you know, the probate conservatorship. Well, that has worked to their favor, right? To Team Con's favor up until now, right? Because they want to have their cake and eat it too. They want to, sorry, I get distracted with the comments. They want to use, they meaning Team Con wants to use these LPS Act conservatorship stuff whenever that is not what Brittany's in. So why are you even using that, right? So he's saying there is a statute. There's actually a law where if you are in an LPS conservatorship, okay, then those proceedings are not public. But if you think about, let's apply our best friend common sense to the equation here. Why would LPS conservatorship hearings need to be private? Well, because they're for mental health purposes, right? That necessarily means a bunch of medical records are going to have to come in, right? It necessarily means that there has to be doctors and all this stuff coming in where we don't necessarily know. I mean, there's lots and lots of different reasons other than mental health that you can be in a probate conservatorship. That's why medical records in a probate conservatorship are still sealed, but the proceedings are not supposed to be sealed, right? So Christopher is saying LPS cases do not follow the same rules of civil procedure. There are several types of hearings under the LPS Act. Some are in the nature of administrative hearings before non-judicial officers. So he's saying we're not even necessarily always in court. You know, he's mentioning here it has something to do with a jury, right? Well, if you think about things being public and non-public and what his reasoning was at the very beginning earlier, the reason, you know, that it's okay that it's not public is you have a freaking jury in there. There's a jury. There is the public is in there and it is observing what the judges are doing, right? The court held that construing Section 5118 as making all LPS proceedings, secret, is consistent. Wait, hold on. Let me just read this first before I try to translate it. The court held that construing Section 5118 as making all LPS proceedings non-public is consistent with the confidentiality of patient records as mandated under the LPS Act itself. Exactly. So basically he's saying like, yeah, okay, if you're in a jury trial, there's probably going to be evidence presented about this person's mental health. And if that is going on, we need to protect that person's privacy of their medical records, right? He's saying there's no comparison in a probate conservatorship because those are governed by laws that are applicable to civil actions. It's just a regular civil case. You have civil cases and criminal cases, right? Civil, criminal. Probate is just a regular civil case. There's nothing special about it, is what he's saying. Because probate proceedings are governed by the same rules as civil actions, they are public, and the presumption of public access applies. Okay, I agree. So now he's going on to another big section of his argument. And this one, sorry, just making sure nothing's popping off in the chat. You know, I don't have no moderators or anything. The termination of the remote audio access program, he's saying, violated the free speech rights of the public and media under our federal and state constitutions. Now, he's bringing in the federal constitution. I'm expecting this could go to federal court if this is denied, which is not something that the California probate courts want. Where the state attempts to deny the right of access in order to inhibit the disclosure of sensitive information, it has to be shown, right? The state is the same thing as the court in this circumstance. So the court must show that the denial of like leaving it open to the public. Let me see, I'm kind of off the screen here. Okay. The court has to show that this denial is necessitated by compelling government interest. Someone told me yesterday that yesterday was their first day of con law. So you are going to be needing to write this down for your notes. And it's narrowly tailored to serve that interest. Okay, so this is a very common constitutional standard where the state attempts to take away someone's constitutional right. They have to meet a certain burden and a certain threshold. This burden and threshold is defined as follows. It is a compelling government interest, and that whatever the action is that they took to take away someone's right is the most narrowly tailored, meaning like the least overly broad type of situation as possible. So the Supreme Court, I'm assuming that is, yes, this is the Supreme Court of the United States, in Waller versus Georgia, identified 4 requirements. So we're about to get 4 requirements. We're going to get exactly what the requirements are right here. To justify the exclusion of the public from a court proceeding. Number 1, first, the existing of an overriding interest likely to be prejudiced absent the closure. Okay, hold on. Let me translate this here. The existence of an overriding interest likely to be prejudiced absent the closure. Okay, so what we're starting with, like, imagine, if you will, a scale, right? And on both sides of the, like those old legal scales. Okay. On one side of the scale is the public's right to see these open hearings, right? Whatever we put on the other side of the scale, let me see. Okay, so that here's us over here. Here's our right. Whatever we put on this side of the scale, it has to actually be heavier, right? It has to balance out. It has to unbalance our right. So we have a pretty strong right. It's protected by the First Amendment of the United States Constitution. So whatever the court's interest may be, right, has to be so important that it has to override all of our rights to be able to know what's going on in the court, okay? Number 2, the closure of the courtroom has to be narrowly tailored, which is another way of saying it cannot be broader than necessary to protect that first interest we just talked about, right? So an example Chris gave yesterday was, well, maybe we could have just not, had access to the private parts of the testimony. Or maybe, we could have heard the first part and then they closed it for the second part or whatever. But he said yesterday that it wasn't narrowly tailored. And this is just a legal term of art, a fancy way of saying, like, did you do the most, or did you do the amount that was like okay and acceptable? Did you go unreasonably above and beyond by closing this court every single time Brittany's had a hearing? Seems like Christopher would say the answer is yes, but I do not want to put words in his mouth. Okay, so the first 2 things are the government has some really big interest to keep the public, it sets the scale off, right? That's the first requirement. Second requirement, you have to make sure as a judge that you're not going completely overboard. Third requirement, there's no alternative to closing the proceeding. Okay, so if there's a reasonable alternative to closing the proceeding, like, I don't know, maybe trying to figure out who it was that was doing the recording, telling them to stop or whatever, Judge Penny did not even think about an alternative. She just shut the program down immediately and it was over the next day. And then the 4th requirement is the trial court must make findings adequate to support the closure. Okay, I don't really know that which trial court. I'm not really sure what's going on with number 4, but that's what it says. Okay. The court cannot determine the application of the above principles in the abstract. It has to be determined by reference to the facts of this specific case. So this is not a overbroad, like, oh, anytime these 4 things apply. It's like, no, you still have to take it into consideration what's going on in the case, right? And listen, I'm willing to admit that it is possible there's some things that the public does not need to hear about Brittany's case, in particular about her medical treatment or any very sensitive things that happened to her that, she's uncomfortable like sharing with all of us. There's certain things, like, I would think Brittany's interest overrides ours. That's just my opinion. It's just my thoughts, okay? But we have to look, it's not just, okay, 1, 2, 3, 4, checked all the boxes. All of a sudden, here we go. We're going to have some open court. No, you have to actually still listen. You have to actually still look at, what the facts are of your particular case. Findings are also required by the California Constitution. Okay. So now we're going to get into the California constitutional requirements. These findings are required to support state action limiting court access. A statute, court rule, or other authority adopted after the effective date of this subdivision that limits the right of access shall be adopted with findings demonstrating the interest protected by the limitation. I don't know what this quote is. Chris, can you give us some translations here? A statute, court rule, or other authority adopted after the date of this rule that limits the right shall be adopted with findings. Okay, so they're saying same thing as above. If you want to limit things, then you need to show us you need to make some factual findings of why you did that. You got to tell us why. You can't just say, RAAP over, bye. You have to tell us why you did that. Okay, so now his argument is, when the court canceled that audio program that let us hear the hearings live, the news release stated that it was a temporary program during the pandemic and widespread breaches by the public. Widespread breaches by the public in a recent court proceeding highlighted the need to return to in-person open courtroom proceedings, which is a welcome development. The announcement was made June 24th, one day after the recording took place. To the extent these are findings, the court stated its governmental interest in enforcing the rule. Okay, so he's saying, all right, I guess we could say these are the findings. I mean, they only did it one day after, but okay, let's give it to them. Let's give them the benefit of the doubt. Okay, these are their findings. Well, if that's the case, then they're saying that their governmental interest, right? Remember that thing we have to put on the other side of the scale? They're saying they're that thing that's supposed to outweigh all of our rights, is enforcing a rule against recording or broadcasting. So their desire to not have anyone record is more important than our First Amendment right to know what's going on in our courts, is basically what I don't know why I keep calling him Stephen. Chris is saying. He said the court noted the program was intended to be temporary during the pandemic, but the court did not explain how the cancellation of the entire program due to violations in one case during one proceeding was necessary to protect the public interest. Oh, sorry. The court did not explain how canceling the whole program because some people violated it was necessary to protect that interest. And again, what is that interest? That is the interest in enforcing the rule that prohibits recording and broadcasting court proceedings. So Christopher's saying, well, they have to come back. Come back here to this press release and y'all tell us why and how it is that canceling this program for all of us somehow protects your interest. It's just y'all didn't use no logic. All you did was stated two facts and hoped that we made a conclusion. Christopher says no finding was made that the recording occurred by one of the RAAP listeners rather than one of the 15 participants on the Court Connect. Nor did the court explain why the elimination of social distancing measures for its courthouses necessitated discontinuing RAP. So not only they don't know, basically Chris is saying, look, they got lawyers on this other program called LA Court Connect, LACC. How y'all know they didn't record it? And another thing, what does social distancing have to do with eliminating this program? Y'all never gave us any kind of logic and any kind of arguments. All you did was threw a bunch of facts out there and hope that we put them together like they were supposed to mean something together. But really, what does social distancing have to do with anything? And again, remember, they're not discontinuing this LACC, which is also just new for the pandemic. So they're letting the lawyers appear remotely, but they're not letting the public appear remotely. And I think that's one of the big problems. So he says, the court's reason for canceling RAP, the end of social distancing in its courthouses, is contrary to recommendations of the Judicial Council against returning to pre-pandemic operations and encouraging courts to continue providing remote access to the public and media because it serves the governmental interest in providing transparency, access to justice, and reduces the need to travel. Okay, so what Chris is doing here is actually very smart. If you look at our scale we set up, right? Oh, this microphone's in my way. We have our scale, right? Our two sides of the scale. All these cameras and screens. Okay, here's ours over here. Here's the public interest. So far, they haven't done enough to outweigh our interest, right? So, oops. Christopher just found not only is it our interest over here on this side of the scale, which is keeping it open, it's also the government's interest, because the Judicial Council just told you themselves it's in our interest to keep this transparent, open, access to justice, reducing the need to travel, better for the environment, right? All this stuff is just piling up on our side of the scale to keep this thing open and to keep this thing recording and to keep this program going. So very smart legal maneuver that he did here. And honestly, it's not even that much of a maneuver in so much as it's just pointing out the facts and the common sense. The Judicial Council just told us this month or last month, hey, everything that y'all did in your courthouses to keep it open to the public, keep doing that. Do that again. Don't stop doing that. And in fact, expand it. Sorry, lots of things are happening. The statement canceling RAP does not satisfy the requirement to make findings that the limitation on court access was necessary to protect the court's interest in preventing participants from recording or broadcasting proceedings. Now, I'm going to make this actually just a different color so we can compare them later. So this is a government interest. He's saying, here's a government interest. Keeping people from recording and broadcasting proceedings. But guess what else is a government interest? Transparency, access to justice, and reducing the need to travel. So now we'll put that one back in yellow. We'll put this one back in yellow because I want our interest to be in green. Sorry, I'm like going through my color coding as I go. If it's confusing, my bad. Don't worry about the colors in that case. Okay, so essentially what he's saying is the statement that they put out talking about we're going to discontinue it and cancel it because, oh yeah, that's a hairless cat. We're going to discontinue and cancel this audio program because a bunch of people recorded it. Well, Chris is saying y'all did not do what you were supposed to do. You're supposed to say who recorded it, how. You were supposed to narrowly tailor. You were supposed to actually make some type of findings. You were supposed to make sure that the person who recorded it actually even recorded it from RAP, which you don't even know. And your bosses basically just told you that you're supposed to be keeping this stuff open. So what's good is essentially what's going on here. Okay. Number one, no compelling government interest exists in preventing the recording or broadcasting of public proceedings. Now, I will say here, the government, if they're going to argue against this, is going to argue against this, and they're going to disagree here. But I am interested to hear Christopher's argument. So he's saying there's no government interest. So basically, he's predetermining, like, y'all ain't going to be able to come up with nothing, and this is why. The court rule regarding broadcasting and recording of proceedings states the governmental interest. Okay, so what is this that we're going to put on their side of the scale, right? Ensuring the fair and equal administration of justice, adjudicating, which means like just being a judge, and controversies, both civil and criminal, in accordance with established legal procedures and the calmness and solemnity of the courtroom. Okay, so this is their government interest that they're alleging and they're trying to say. So our government interests are going to be green for now. I'll figure out a better color coding system. But, you know, it's like when you're teaching constitutional law on the fly without reading a document first, it is a little bit difficult. Okay, so what is their government interest? Ensuring the fair and equal administration of justice. Sounds right. Civil and criminal, in according with legal procedures, and the calmness and solemnity of the courtroom. So it has to be calm and solemn, all right? Although the government has an interest in the orderly administration of justice, that interest is not absolute. Like, you know, it's just a thing to put on the scale. It's not like, oh, boom, scale over. You know what I mean? I hope this scale analogy makes sense. It's kind of how I think about it, like those old school scales. A clear and present danger must be shown to prohibit the exercise of free speech. Okay, so here's your standard. Brenda. Actually, I shouldn't say Brenda because I don't think she has like actual control over whether or not this program like exists. But there must be a clear and present danger shown to prohibit the exercise of free speech rights. And the Supreme Court described that in Pennekamp in 1946. So here's the description the Supreme Court said. Whether the threat to the impartial and orderly administration of justice must be clear and present, or a grave and immediate danger on which is close and direct or disturbs the court's sense of fairness depends on a choice of words. Under any one of the phrases, reviewing courts are brought in cases of this type to appraise the comment on a balance between the desirability of free discussion and the necessity for fair adjudication, free from interruption of its processes. Okay, so this is something like having to do with interruption of the process. And listen, one of y'all asked me yesterday, what is actually the deal? Like, what's actually going on? Why do they even really care so much? Like, all of us have just sat around and agreed, oh, yeah, there shouldn't be recordings in the court. But when you really ask why, I cannot think of any really good reason. And some people did think of good reasons. But being free from interruptions of its processes, what does that have to do with people recording? Nothing. People could be recording silently and quietly. There is no blanket prohibition in the California Rules of Court against recording and broadcasting non-confidential court proceedings. This also, you know what I just thought of? It may be the case that these, I don't want to give away the secrets, but that's kind of what I do. Sorry, Christopher, if this is true. But it may be the case that some of these media companies are trying to maybe Ted Bundy this trial, right? Like broadcast it, put the cameras in and do all that. Who knows? Who knows? Maybe people are trying to make documentaries. Maybe people are whatever. Now, I have no idea. All I can say is this is USA Today, which I don't think they're making a documentary. I have no idea. But he's saying, look, listen, there's actually no blanket prohibition of recording. Rule 1.15 says that the activities may be permitted as circumscribed in this certain rule if executed in a manner that ensures the fairness and dignity of the proceedings. And the proceedings are not affected adversely. So here's your standard. You can record as long as there's still going to be that fairness and dignity in the proceedings, and you can't mess up the proceeding in some way, right? The rule doesn't create a presumption for or against granting permission to photograph, record, or broadcast. Because the law is neutral on whether to grant or deny permission to record and broadcast, it cannot be said that the government has a compelling interest in preventing the activity. The interest is legitimate and substantial and does not override the right of access. Okay. Concerns about recording confidential court proceedings do not exist here because the court may exclude the public and media from having remote access to any portion of the hearing that is confidential, just as it would close the courtroom, leaving no risk of recording. So he's saying okay, but if they're in the courtroom, they can record. If they're, not, I guess here, my devil advocate argument here, Chris, would be you kind of can see there's police officers in the court that come around and say, put your phone up, or they take you out of the court. Right. But if you're watching it or listening to it from remotely, maybe you will record it. You know what I mean? But again, I don't care. Who cares if they're recording things? Brittany literally said she wanted it to be public. Concerns about recording confidential court proceedings do not exist here. Okay. The Judicial Council report on remote access states the government's interest in providing transparency to the public and media operations and encourages courts to continue providing remote access even after the pandemic is over. So the government's interest in transparency to the public and media of its operations. Okay. So this is the government. Oh, shoot. This is the government interest. The funny thing is, he's kind of using the government's interest against their own selves. They're saying okay, not only do we have a right, we know y'all don't care about our rights. What about your own damn right that you made up yourself? You said it, Judicial Council. These things should be still open. So why is it that one day after Britney Spears called y'all out and said that the courts should be in trouble, is it that y'all want to keep this all hush-hush now? Stephen didn't say that. I don't know what age the people who watch my stuff are, but if you are of a certain age, then you know about Barack Obama's anger translator, Key and Peele sketch that they used to do on what was it called, Mad TV or something. But I'm basically Stephen. Why do I keep calling him Stephen? Christopher's anger translator. So that's my translation. Those statements contradict statements made when the rap was canceled. Exactly, right? He's about to say what I just said, but in a better way. Returning to pre-pandemic conditions and removing remote access because of recording without assessing and competing. Okay. So basically what he's saying is these statements up here by the Judicial Council that we need transparency, and there needs to be more transparency. We should keep doing these audio things and all that. Well, that's in direct contradiction to whenever y'all said that this is canceled and we're, returning to pre-pandemic conditions and removing remote access without accessing the competing and overriding need for transparency. So he's saying, like, y'all didn't even think about this whenever y'all canceled that. Here's a footnote. There was nothing confidential. There was nothing confidential about the proceedings that were recorded on June 23rd. The statement was made in open court and public proceeding. When she said she wanted her statement to be made in open court, she was asked whether she wanted the proceedings to be closed. She said, I think they've done a good job at exploiting my life in the way that they've done my life. And I feel like it should be an open court hearing and they should listen in and hear what I have to say. And we all have heard that many times now. Number 2, he says, eliminating rap was an overly broad reaction and it infringed on the right of the public to access the court. Okay, so remember that narrowly tailored? The other side of narrowly tailored, the opposite, right? The antonym is overly broad. He says, even where the government's purpose is legitimate and substantial, and he's saying, your purpose here isn't, but even if it was, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties. When the end can be more narrowly achieved. So he's saying y'all went too far and you need to come up off of that a little bit. The government's stated interest in regulating recording and broadcasting is to ensure the fair and equal administration of justice and the calmness and solemnity of the courtroom. So he's saying, all right, here's your fake stated interest, court. Those are important, but they can be accomplished without taking away remote access. The judge presiding over the hearing may have been justified in turning off rap access during the proceeding when it learned of the rule violation, so it could prevent further recording until it could investigate the matter. So he's saying, all right, listen, I'm not even going to really fight you on this. During Brittany's hearing, whenever they discovered that she was being recorded and things were being recorded, okay, fine. Maybe that was okay, just cutting it off that day. He said, but the subsequent, going a step further and abolishing remote access by the court's administrative action was an overreaction. The court was not justified in removing remote access to the public and the media while maintaining that privilege for parties, counsel, witnesses, and others. Oh God, I think I'm allergic to something in this microphone. Like, does anyone know if these things have latex in them? Because it makes my nose itch every time. The court was not justified, he's saying, because listen, y'all are letting y'all letting Vivian Lee Thoreen and Bruce S. Ross call in, so why we can't? Denying the public and media the right to remotely access the court proceedings through rap, in all cases, based on one incident, punished the public and media for misconduct that might have been caused by some one of these lawyers. The reaction was hostile to the public and media's vital role in the administration of justice. Wow. It was hostile to the public. So basically he's saying it was unconstitutional. Like he's saying y'all violated the Constitution with this. When a recording or broadcast is made of public proceedings in violation of this rule, the court may punish the offenders. That is constitutionally permissible because the state action is content neutral. If the government's aim was to prevent recording, it did not accomplish it by eliminating rap. The risk of illegal recording is still there with LACC, that Court Connect, and even with those attending in person. Yeah, exactly. Like you could have a secret recorder and be recording, right? They kind of just like punished the public's access to listen to these hearings. They took it away and they didn't really, like they're saying, oh, we didn't want people recording. Well, people can still record. So what does RAP have to do with anything? The risk of illegal recording exists with LACC participants and even those attending in person. Therefore, denying remote access does not address the evils the court was trying to address. The court could have investigated the violation, punished the offenders as a remedy, tried to dissuade others from violating the rule, but the court has not stated publicly if it has even attempted to do so, or if it even knew who broke the rule. The court could have issued additional warnings against the recordings and advertised the punishment available if someone is caught, as deterrence against future violations. So he's saying all the alternatives they could have done, and they just didn't do anything. They just eliminated our ability to even ever see it. The effectiveness of those narrowly tailored remedies were not tested by the court. Instead, it shut down remote access for everyone in all cases. Because the court has no compelling interest in preventing the recording and broadcasting, recording and broadcasting, yes, Christopher, of public proceedings, and its remedy was not narrowly tailored to serve its interest, the cancellation of RAP violated our federal and state constitutions. Yes. Let me see. Can't believe I know the cat. She's meowing. Yeah, I literally think that I'm literally allergic to this microphone. Like, my nose itches so much, and it's only when I use this microphone. The right of the public and media, and I have a latex allergy, so I'm wondering if there's latex in here. The right of the public and media to equal protection under our federal and state constitutions was denied by terminating remote access to them while affording that right to other participants. The 14th Amendment to the United States Constitution, y'all have heard me say this so many times, provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. It guarantees no minimum of protection, but requires that persons who are similarly situated have to receive equal treatment. The government may make a reasonable classification of persons and other activities, if not arbitrary, based on a difference in the classes that substantially relates to a legitimate objective. So that's like a fancy way of saying we don't allow discrimination under our laws. The laws apply to everybody, but there's some exceptions, like, age laws. Like maybe you have to be a certain age to drink or something like that, right? That would be one of these classes of people, right? That's different. Oh my God. I'm literally having an allergic reaction to something. So the California Constitution expressly prohibits the denial of equal protection of the laws. So, right, the United States Constitution gives you the floor, and then even more rights come in with the California Constitution. It prevents special privileges or immunities to particular citizens or classes of citizens that are not granted to all. It requires the uniform operation of general laws and barring local or special laws when a general statute can be made. So listen, if we can have a catch-all rule, that's what we have to use. That's what the Constitution says. Sorry, reading a couple of your comments. Oh, wait. Hold on real quick. Savani, is this like a common thing? Do these microphones make people's nose itch? Is it common? Okay. I'm going to have to replace it with something because this is, oh my God. It's like I need medical attention here. Got my EpiPen on lock over there. Okay. So then he goes on to say there is a 2-tier test for when classification is constitutional. In ordinary equal protection cases not involving suspect classifications, a suspect classification is one of those classifications that is mentioned in the 14th Amendment. I might not be able to get them all, but it's called sex, right? But it's been interpreted to mean gender, religion, national origin, race, gender, or sex, national origin, religion, and there's a couple other like specifically enumerated like things. It's like it's a suspect. Well, a suspect class in particular is race. I know that one, and national origin. So if it's not one of those like hot, like, okay, basically if a law is saying like, okay, no, I don't want to like be too controversial here, but let's say like, let's pretend that there's a race of people on the earth who are gray, and I am aware there are not, but let's say there's some gray people in the United States, and that's a race. And if there's a law that says no gray people can be out of their house after 8:00 at night, well, that is a suspect class because you just classified somebody based on their race, and that might be unconstitutional. But then we have to bring in that test, right? Remember those scales? All right, y'all just did something that looks bad, and that's already weighing against you. But maybe it's the fact that gray people turn into werewolves and then they lose control of their ability to do human things, and maybe they hurt people or something. I don't know. I'm just making stuff up because I don't want to get too like controversial here with like triggering topics, but that's kind of how you would go through that analysis, right? So there's a 2-tier test for whether a classification is constitutional, right? So gray people or whatever, right? In ordinary equal protection cases that don't involve suspect classifications like race and stuff like that, or the alleged infringement of a fundamental interest, the classification is upheld if it bears a relationship to a legitimate state purpose. So this is just the threshold, right? So if we're not talking about some special class, we're just talking about a general law, a general rule. It's saying, there just has to be, this is the threshold, a legitimate relationship, it has to just be rational, common sense, and it's legitimate, and fine, we'll let it go. But if the statutory scheme imposes a suspect classification, a classification which infringes on a fundamental interest, then that must be closely scrutinized and may only be upheld if it is necessary, right? So up here you're saying, oh, okay, well, if it's rationally related, legitimate, whatever. But down here you're like, if you bring in this classification thing, one of these, especially like a protected class of people, then we have to scrutinize what you're doing. That law, we have to look at it. And it's only going to be able to be upheld if it is necessary. It has to be necessary. It can't just be like legitimate or rational, right? It has to be necessary for the furtherance of a compelling state interest. Not just any state interest, not like, legitimate state purpose. No. Compelling state interest. And that is supposed to be in place to protect people who are ordinarily, or who were and have been ordinarily and historically discriminated against with the laws of the United States. But of course, we have corruption and people don't follow laws. When the court terminated RAP, it created 2 classifications of access. Okay. What are they, Christopher? 1 for parties, counsel, and witnesses, and other people it allows to attend its court proceedings on LA Court Connect, and another for the public and the media who may not attend remotely and must appear in person. This was evident at the July 14th, 2021 hearing, where most appeared via LACC or telephone. The court allowed the ACLU and an attorney for an unidentified interested party to show up, but it banned remote access to the public and media. Reporters who live or work outside Los Angeles and California are disadvantaged because traveling to the courthouse to view proceedings in person is not viable. Eliminating the program infringes on the fundamental interest of the public and media to access court proceedings and provides privileges and immunities to a particular class to the exclusion of others similarly situated. Therefore, the court must demonstrate that it's canceling remote access to the public and media while it provides that same access to others like the ACLU and this unidentified party lawyer. It has to show that it's necessary to serve a compelling state interest. So that's your standard. There are differences between the 2 classes, but each class has a constitutional right to access the court for non-confidential proceedings. So the 2 classes are like the people who can log into that LA Court Connect and the people who are using the call-in on audio that's now been canceled. The parties and counsel have due process rights to attend, and the public and media have a free speech right to do the same. Providing access to one group and not the other does not advance a legitimate objective. The termination of that program for the public and media does not eliminate or even substantially reduce the chance of proceedings. Oh, thank you, Gabby, Naru fan, for the 149. Oh, the black cat. Oh, Ella says thank you too. Come here, Ella. Say thank you. Thank you, Gabby. Okay, get down. She's literally just sits here and watch it. Like, she would be walking all over everything if I let her go. Okay. So providing access to one group and not the other does not advance a legitimate objective. The termination of that RAP program for the public and media does not eliminate or even substantially reduce the chance of the proceedings being recorded. Per that July 14th hearing transcript, there were 18 participants on record and only 3 of them came in person. So basically 15 people used that remote appearance. If the court's aim was to prevent recording, it would have taken away LACC access to everyone. But this actually, Christopher, outlines a much bigger and more pervasive problem that I've been recognizing ever since I started being a lawyer. And that is, people think that if somebody is a lawyer or a judge, all of a sudden, like, they revoked our ability to lie. Like, I try not to lie and stuff, but people just assume, oh, well, it's a lawyer, they're not going to record it and release it. What? How do you know? How do you know that these lawyers, I'm not going to name any names, but how do you know? Or Jamie Spears isn't recording it, or Lynn, or whoever else is. You don't know. So he's saying, if y'all wanted to prevent recording, what about these lawyers? And I'm assuming the court would say, oh, well, we know they're not going to record. But you don't know that. You don't. It's just not logical, and it's not common sense. He said, instead, it continued to provide video and audio access to a favored class of people while punishing the public and media because unknown people violated this rule. Oh, no, I'm not allergic to the cat. We already ran those tests. While punishing the public. He's saying, look, you made these lawyers a special favorite and punished us because some unknown person, you don't even know who it was, violated the rule against recording a public proceeding once. This is such a good sentence. I want to read this one again. This is like a sentence I would write. It continued to provide video and audio access to a favored class while punishing the public and media because unknown people violated the rule against recording a public proceeding once. And you just violated all our constitutional rights because of it. Media outlets are now burdened with having to send a reporter to Los Angeles to view the proceedings in person, which creates an unnecessary expense and a health risk to the reporter and the public due to the pandemic, especially for those based outside of California like USA Today. By comparison, remote access is provided to the other participants through the Court Connect for free, starting September 7th, 2021. There are few seats available in the courtroom with heavy demand by the public and media to attend. It's true. It's true. It's true. There's lines. Remote access would reduce the need for reporters to choose between traveling to Los Angeles to appear in person and forego observing the hearing. Requiring the public and media to attend in person while allowing other participants to appear remotely infringes on the right of access by treating those members of the public or media who cannot find a seat in the courtroom or travel to the courthouse to observe the proceedings different than the participants who the court provides remote access. So he's saying, here's the big problem. You're infringing on our rights. And who is our? It's the people who either can't find a seat, who can't travel. Maybe they have a health condition. Maybe they just can't travel for some other reason. And he says it prefers local media outlets who can more easily send reporters to attend in person than media outside of Los Angeles. The disparate treatment of the two classes is not justified by a compelling government interest. Remember, that's our standard. So it fails to provide the equal protection under our federal and state constitutions. So here's his request. Perhaps trying without the mic cover. Yeah, the cat is hairless. She doesn't have hair. Okay, so here's his request. He wants findings. Due to the importance of the issues raised by this request, the court should state its reasons and any findings of fact should state its reasons and any findings of fact that it makes to support any denial of relief. This is not required, but it is helpful for appellate review. Bingo. Christopher, I wish he was here right now because I would just tell him good job here. Remember how I've been saying, I think he's going to bring this to federal court. I think he's going to bring this to federal court. I think he just told us he's going to bring it to federal court. So they better just go ahead and reinstate the audio program. So he's saying, look, I'm asking you for the findings of fact. I want to know your facts. Remember those facts? We were talking about those findings earlier. I want to know those findings. You don't have to, but it would be helpful for when I appeal you after you deny this, is basically the Anger translation version of what this says. As explained in this case, under former Rule 980 of the California Rules of Court, what do you mean former rule? 980 of the California Rules of Court regarding recordings of court proceedings, here's the quote. If the court decides to deny access after evaluating the relevant factors, it would be helpful if it could explain its ruling so that any later challenge could be objectively analyzed. A silent record is of little assistance. I bet you this is what Penny's been working on. A silent record is of little assistance to an appeals court in determining whether you were right or wrong in making your order. We therefore urge the trial court, that means like the lower court, right? The court of first instance, the first place it's heard, to briefly explain on the record why access is being denied. We believe the benefit to justice system from this procedure will substantially offset any inconvenience to the lower courts. Conclusion, USA Today requests that the court grant the relief stated in Section 2 of this brief, and it was filed on the same day that it's dated, and we have Christopher C. Melcher digitally signing. Okay, and now we have the declaration of Maria that he referenced several times in the early part of the document. Number 1, I'm over the age of 18 and I make this declaration of my own personal knowledge. Number 2, she's an well, she didn't gender, I don't know, I'm sure, I think it's a she, but as an entertainment reporter for USA Today, Maria regularly covers high-profile court cases based in Virginia, following several cases simultaneously throughout the country. There is intense and ongoing public interest in the Britney Spears conservatorship. Media outlets worldwide report on case developments. A Google search for Britney Spears conservatorship on August 19th returned 35 billion results, including 7 million news stories. Hashtag Free Britney. Remote audio access was allowed by the court for the hearing of June 23rd, which enabled USA Today to report on the statement that Britney made. No remote access was permitted for the media on July 14th. To cover the hearing, a reporter from USA Today appeared in person and arrived early to ensure a seat would be available. I am informed and believe the court permitted no electronic devices to be used, so the reporter had to use pen and paper and take notes and wait for a break to dictate the USA Today editors what had happened in the court. That is true. Like, listen, I am not a fantastic note taker, like with pen. And again, there's just no reason. Like, I saw Judge Penny in her particularly, like, I've been following these court cases for a year. It used to be somebody would go in and type on a laptop, type notes. Well, then they found out that we were, reading those on the internet and they didn't like it. Then it was like, okay, no recording devices. Then it was like, no, all now you can do is have a pen and like you have to turn your phone off. And if you're even looking at your phone, you get kicked out. And it's like, it got like more and more and more and more and more and more restrictive as the year went on. And now they're doing this thing, right? So I can confirm that this did happen. The reporter had to use a pen and paper to take notes and wait for a break to dictate to USA editors what actually had happened in court. She said she received those notes for her reporting. The process was slow, expensive, inconvenient, and it provided less information than was available when remote access was provided for the prior hearing. To accurately report on court proceedings requires observation by the reporter in person or through remote means, or at least a reliable source who knows what happened. Reviewing filed. Sorry, I lost my spot. Okay. Reviewing file documents and transcripts is important, but it does not replace the experience of listening to the hearing. Even when these documents are available, they don't tell the whole story. The demeanor of the witnesses, the tone of voice of the judicial officer, and other subtleties cannot be gleaned from a document. It can only be done through observing the proceedings in person or remotely. I agree, because now we're in a situation where it's like, oh, hiatus Brittany on Twitter is saying, oh, thank you, my Roberts, my auditory processing queen. Yes, oh my God. Is anyone else not a, what do they call it? Auditory learner? Like, I cannot. Okay, yes. Thank you so much, my Roberts 626. Oh Lord, can't read either. Bless my heart. All right. So where are we at here? Okay. So again, right, I totally agree with him. He's saying, there's all kind of stuff that's happening that we don't even know. Brittany might be crying. The judge might be being mean. Anything could be happening. We don't know any of that from reading court documents, right? When remote access is available, my preference is to watch or listen to the proceedings. In-person attendance is usually not an option for me because of the distance of the courthouse from Virginia, the number of cases I follow, limited funding for work travel, and health concerns due to the pandemic. Many journalists are similarly situated and cannot attend court in person for the cases they cover, which I'm informed and believe to be true from working on for other reporters for many years. Number 8, it is crucial to have immediate access to information to report on court proceedings. When the public closely follows a case like this one, reporting is needed for every step. I agree. It is expensive to order transcripts. It is. It's like hundreds of dollars to order the transcripts too. That's another thing. Rush orders can cost thousands of dollars for lengthy hearings. The story may have passed by the time the filings or transcripts can be obtained. Well, I don't have that much sympathy for the story might have passed. I don't really care about that. But the story might have been told in a fake way, right? We've seen CNN do this fake news where they like, Jamie Spears agrees to step down. And it's like, no, he didn't. He said he would step down eventually when the time is right. And that could be years. Like, when you only allow some people, those same little favorites into the courtroom, and you just have to rely on them. And you just have to rely on them to tell you what happened. It's like, well, what if they're not actually credible? CNN, entertainment reporter. Okay. TMZ. Does TMZ even go in? I don't even think they bother going into the courtroom. USA Today will cover the hearing on September 29th. If remote access is not provided, a reporter will have to appear in person, attempt to find a seat, take notes by hand, and relay the information to an editor like the last hearing. And that is going to substantially limit the ability of USA Today to access the court, to gather news, and to report on this and other cases in the court. I'm informed and believe the same will be true for many other reporters. I will abide by the rule against recording or broadcasting of the proceedings if remote access is granted. I declare under penalty of perjury, blah, blah, blah. Okay, and that was Maria Puente. Okay, so now the notice. Okay, so this is just like a technicality type of paper. They're filing notice, telling you where their exhibits are. Exhibit 1. So, okay, that's basically the end of this document, and everything attached here is just exhibits. So this is that press release. Oh, sorry. Notice. Okay. Program that allows attorneys, members of the public to listen remotely to hearings. So this was in January of this year. So this was, wow, like almost a year after the COVID pandemic started. That's kind of late. Attorneys and members of the public will be able to listen to these court proceedings. We're implementing this as a part of our ongoing effort to ensure public access. Okay, so this is just a description. We've already kind of read this. In-person courtroom seating. And this is when they were making people spread out in the courtrooms. Okay, Exhibit 2 is the LA Court Connect user guide, where the thing that the lawyers use. Let me see if this will probably be easier. Number 3 is the news release. Courts provide Court Connect free of charge during Delta variant surge. Oh, interesting. So this was really recent. What's today? The 30th? This was 11 days ago. They said the court was going to keep LA Court Connect to be free during the Delta variant surge. Using one-time COVID state budget funding, there's not going to be any fee. Okay, so this judge, Eric C. Taylor, announced that it will waive the cost for all hearings beginning on this day, Tuesday, September 7th. It's remote courtroom appearance technology. Yeah, okay. The announcement aligns with the recent report issued by the Judicial Council of California, which we've read now. Exhibit 4 is going to be just like a transcript of... This is like a transcript from the hearing. That's why it's so long. That's why this document was so long, because he attached transcripts. Then we have Exhibit... What is this? Exhibit 5. Presiding Judge Eric Taylor rescinds... Okay. So we had on that exhibit just now. It was like, oh, we're going to keep LA Court Connect open so all of the lawyers can come. Oh, but in June he said one day. That was what was really messy, that they didn't wait at least a little while, right? They should have waited some time between the Britney hearing, her talking, and canceling this thing. So he's saying, no more social distancing requirements in the courthouse. And also, we're not going to let y'all listen to the court anymore. I know I said I was going to upload this yesterday and I didn't. I will upload this today. And y'all can just kind of scroll through and read this on your own time. This is another transcript from July 14th. I was there. Oh, look, we have Loeb and Loeb. Well, let's see if we can find our good friend Bruce Ross. Where is he? Here he is, Bruce S. Ross, formerly friends with Vivian, went to Congress with Vivian, went to the Supreme Court with Vivian, and then came to represent Bessemer Trust, who is supposed to be a check and balance on Jamie Spears. So y'all can sort that out. Oh, thank you, Sharon. Thank you for the $5. That's very nice. Thank you. So then what else is happening here? Jody Pace Montgomery. Pace. That must be her maiden name, right? Okay. So then we have Exhibit 7, which is the Judicial Council of California's, report saying that they want all this stuff to still be open. Let's see. 46 groups present their input to changes on the court processes. Work group recommends California expand. So here's the part that Christopher wanted us to look at. The work group recommends that California expand and maximize remote access on a permanent basis for most court proceedings and should not roll back the increased access to pre-pandemic levels. And so, well, that sucks because that's exactly what Eric C. Taylor, Mr. Judge, did. Interim report, access to courts. Let's see. What is this? Did he highlight this? Oh, no, that was me highlighting. What's he have here? Got a little chart. I don't know. This is a long thing. We don't have to read all that. Okay, and then these are the original. Oh, I think these are all of the. Okay, this is pretty good. I did skim through this part of the thing. I think this is all the media requests that have been submitted, right? Here's Law and Crime. And this is like a long time ago, right? These other ones from earlier are from 2008. Look. Media, who was it that was asking? TMZ. Mike Walters from TMZ was trying to come in February. Think that one was denied in 2008. Now, who do we have here? Story Syndicate. Isabel Evans. We have People Magazine. Thomas Antonio Mayer. We have who else is in here? Law and Crime Productions, who wants to broadcast. Oh, thank you so much, Sharon. Thank you. Oh, little ducky with your little cape. Law and Crime Productions. This is all from 2021, right? You can see the dates up here. Entertainment Tonight, Joseph Corral. These are all, I think these were all denied. Story Syndicate, Isabel Evans again. Oh my goodness, Julie. Oh, okay, I have to stop and read this one. That is so nice. Thank you so much. Thank you for your work on explaining the Free Britney case and explaining everything in layman's terms. Your law professors should be proud. Do you know, Julie, I can't get one of them law professors to come on this channel. I think they just don't want to be involved in anything. But I have talked to some of them and they are pretty excited about it. Which is cool. Thank you so much. That is so nice, Julie. You are so generous and kind. I really like you guys. Y'all are so nice to me. Okay, who else? Law and Crime again. Law and Crime, Law and Crime. So he's just including oh, look, remember this? Remember you told TMZ no? Remember you told Marley Goodman no? Here, look, back in your face. Look, People Magazine asking again. People Magazine. Who is this? Story Syndicate. Sarah Gibson. Oh, so this is the Netflix people. Okay, cool. So Netflix has been trying. That's the Story Syndicate, I guess. Oh, here's a letter. I guess we can read this one from Aaron Lee Carr. We are respectfully requesting, this is from May, permission to have a film camera inside your courtroom. When Britney addresses the court, we believe the filming of that proceeding is in the public interest, as more than 1 million U.S. citizens currently remain in conservatorships, and the public deserves to know those processes and procedures. Now, this is the Netflix documentary people writing to the judge, writing to the court, saying, let us come in there with a camera. For the last 2 years, we have been producing a documentary feature film for Netflix about the conservatorship of Britney Spears and about the issues that arise from such conservatorships. Britney's case has shown a spotlight on the topic of probate conservatorships in California, an issue of immense public interest and journalistic importance. This provides an opportunity for the world to hear Britney's own words about how she feels about her situation. The factors outlined in the California Rules of Court favor the presence of cameras. So Erin and her lawyers, and maybe she wrote this herself. I don't know. Maybe she's a lawyer. I really don't know. But she's going a step farther than than Christopher did. And she's saying, actually, the rules do favor the presence of cameras. See, Christopher said it was neutral. It was like, there's no favor, there's no preference, but there's just neutral. She's saying, no, actually, the rules of court favor that you let us in with our camera. And the reason is the issues at stake here go way beyond the obvious public interest in Miss Spears and her conservatorship. The focus on this specific case has also increased the interest in and scrutiny of the system of conservatorships in general. Yes, Erin. Accordingly, allowing the public to witness these events undoubtedly serves the interest in maintaining public trust and confidence in the judicial system. Similarly, allowing the filming of the proceeding promotes public access to the judiciary. Additionally, factors that normally may weigh against the presence of cameras are not present in this case. For example, there's no jury here, so no concerns about tainting the jury are present, nor would the presence of a camera be disruptive or interfere with the neighboring courtrooms, as the size and intrusiveness of camera equipment has been greatly reduced. Public access to judicial proceedings is a hallmark of American democracy. True, Erin, I agree. As the United States Supreme Court recognized in Press Enterprise blah blah blah, the value of openness lies in the fact that people not actually attending trials can have confidence that standards of fairness are being observed. That is excellent. Let's read that one more time. The Supreme Court has said this before, and this is the sentence. The value of openness lies in the fact that people who don't actually get to go to the trials, I'm paraphrasing, can have confidence that standards of fairness are being observed. The sure knowledge that anyone is free to attend gives assurance that established procedures are being followed and that deviations are going to become known. Okay? The court should have been open to the camera on this day. To the public. I don't know about camera. Camera's like a step farther, right? That's a different thing than like recording or whatever. Like having a big news camera. And again, like Erin said, well, the size of that equipment has been reduced, right? People in open society do not demand infallibility from their institutions, but it's difficult for them to accept what they are prohibited from observing. So the Supreme Court has basically come out and said, like, okay, well, the people aren't really saying y'all got to be perfect, but at the very least, like, they can't just take your word for it. You have to leave the doors open. She says, in our society, the media serves as a proxy for the public. But even the most experienced journalists cannot replicate the sights and sounds of court proceedings without the aid of both audio and visual equipment. As Justice Stewart explained in another context, if a television reporter is to convey sights and sounds to those who cannot personally visit the place, he must use cameras and sound equipment. Yeah, exactly. Here, where the case involves an internationally famous public figure embroiled in a years-long controversy that has invited increased scrutiny upon how society cares for those who may be unable to care for themselves, the interest in transparency and public access are at their greatest. Accordingly, I respectfully ask the court grant our request to film. Claps for Erin and whoever else perhaps helped write this. If Erin wrote it all by themselves, then 10 out of 10, Erin. I love that. And it still got denied, right? So then again, here they are again. May 12th, they're trying to get in. Order is denied. Associated Press. Now, see, this is May 2021. Now we're about to see some more people besides TMZ and Netflix and People Magazine trying to get in this courtroom. So now we have the Associated Press. Law and Crime. They try every time. Good for them. Law and Crime Trial Network. Australian Broadcasting Corporation tried to get in there. I guess these are like broadcasting or something. Entertainment Tonight again. Joseph again. CAB-TV, Channel 7, Eyewitness News. Susanna Chamberlain tried to get in there. Fox 40, Sacramento. Barnett Parker. Fox 40, Sacramento. Then we have KNX, whatever that is. Margaret Carrero. They spelled the judge's name wrong. KMX, KABC TV again. These are just a bunch of requests that I guess have just been continuously denied. Who is this? People Magazine. People Magazine again. They're checking off the box. Look, denied. All these boxes denied. Why? You didn't tell us any reason why. And listen. Let's not get carried away. Should there be 45 cameras in the courtroom? Like, no, because then that would also infringe on the right of the people. But when Netflix was making that request, I didn't see anybody else making that request, right? It was like earlier on that they were doing that. Okay, so this is right before the, so she wanted to bring it. So Take Flight Film Limited. Who is this? Online Entertainment, U.S. Broadcaster, TBC. This was the day before the last hearing, right? Denied. What did they want to do? Where does it say? Yeah, denied. Okay. Brenda Penny, denying. KTTV, Fox 11 News, Freddie Beboa, or Beboya. Sorry, I said that wrong. Another news. So most of this is news. A couple of things that seem to be documentaries. Let me just make sure this is okay. Yep, and that's it. Okay, so we've made it through the document. I'm so tired. So we've made it through that. Christopher told us Brittany can take the case to Ventura instead of where it is now. So that means she can get another judge without attacking them. What do you think about this? I actually would have to look a little bit more into what the rules are for transferring a case into Ventura. Actually, I do not know. So if Christopher's saying it, I assume he probably has some good grounds to be saying that. But what do y'all think about Aaron Lee Carr? Like, that was so cool. I liked reading that. Because I know there's been kind of like dispute on like, is the Netflix documentary going to be pro-conservatorship, or is it going to make it seem like Brittany needs it? Or listen, I don't know. But given what I just read from Aaron Lee Carr, it sounds like she's pretty aware of exactly what it is she's looking into. And I think it might be a good one. I don't know. Who knows? We'll see. Keeping an open mind. Let's see. There's no way they allow cameras, unfortunately. I hear Vivian making a whole thing about Brittany's privacy, even though Britt wants to be heard. Yeah, I know. Judge Brittany doesn't want unfairness to Brittany's team versus her gal pal, Vivian Lee Thoreen. Yeah, exactly. She's probably never going to perform on stage again. That's why I hope. Big claps to Erin. She made perfect points. I agree, Bethany. Don't want her forced to do anything. Didn't Brittany say she wants to do new music? I don't know. It seemed like she might have mentioned that to TMZ or something. Exactly, Gabby Naru fan. Denied. How sad. I think Brittany will definitely perform again. Isn't Amanda Bynes in the Ventura courts? I don't know how her judges are. Oh, is she in Ventura? Did not know that. I hope she'll be at. So a lot of people are talking about Brittany like performing again. Will she? Will she not? They're gonna make a movie about this. Yeah, there's gonna be a lot of movies about this. Thank you again so much, Julie. That was so nice. Sharon, thank you also again so much. Twice, Sharon. Sharon twice? Thank you. Same Sharon twice. And my auditory processing queen, my Robert 626. Thank you again so much. Yeah, auditory processing is something I have an issue with. And that's one of the main reasons that I started doing these channels, is because like everybody has different ways they can access and process information. And I know personally for me, it is a lot easier for me to just sit down in the silence with the pages and read it and just have as much time as I need and highlighters and pens. But some people, they can look at that for the rest of their life and they're not going to know what that says. They need somebody to kind of say it because they're more, auditory processors or whatever. I personally am not an auditory processor. I am really bad at it. So the fact that I'm out here doing this It's not really my expertise, but I try to like say things in ways that would make it more easy for me to understand. And that's why I talk slow and I repeat things a lot and I'm long-winded, because I want people to understand the message. For me, that's what's really important. The truth, just the truth. I just want people to understand exactly what happened and then form your own opinion on it. And having the ability to receive the information in lots of different ways, I think is the only way that we're going to be able to give this information to the public, right? Deny. Penny, stop being so complacent. Exactly. Should I ask for a change of venue to Ventura? Maybe that court is not as corrupt. Maybe. But then again, we don't know that. Maybe they're more corrupt. I mean, who knows what's going on over there, right? We would need to like make sure. Corruption, Claire, exactly, is rampant and unchecked. Jody might try to keep Brittany from testifying. It was Jody's lawyer who tried to keep her testimony private. Yeah, I know. Lorianne Wright was the one who was like, oh, we don't know what she's going to say. Well, then you should just hush right now. If you don't know what she's going to say, then shh, be quiet. Let her talk. She might have, my client holds the privacy rights. Like, no, she doesn't. What do you mean your client holds the privacy rights? Like, she does, legally she does. But like, when you really think about it, like, Brittany is telling you with her own words, she wants it open. And you're going to say, well, technically Jody has her rights. Like, that was literally what she went with. Like, come on, Lorianne, chill out. Hashtag free Amanda. Definitely. Hashtag free Amanda. If something happens to Jamie before he steps down, who would take over? Probably someone would be appointed. Thank you, BJ. We really appreciate what you do. Oh, thank you, Leo, for being here. All right. Well, I'm literally in the throes of an allergic reaction. So I'm going to go take a Benadryl and probably pass out or something. But I do want to do another live soon. On the fact that a guardianship abuse or an elder abuse organization did file with the Department of Justice a complaint for an investigation. It was several pages long and it was very, very well written and very, very well reasoned. And the Department of Justice emailed them back within just a couple weeks and said, we're not going to investigate this at all. And, you know, here's the number to your local bar association, which is interesting because I tried to report financial crimes that I found evidence of to the FBI, the Federal Bureau of Investigations in the United States. And I was also told to contact my local bar association. Like, what? What does that have to do with anything? Like, they can't even keep their own attorneys in check. How are they going to investigate conservatorship abuse? What are you talking about? Anyway, I want to go live on that. Am I going live tomorrow? I don't know. Should I go live tomorrow? What is tomorrow anyway? Wednesday? My mom and grandma are coming to visit me for my birthday. Me and Beyonce's birthday is on September 4th. I think it's Saturday. I really don't know. But I'm going to be 31 and my grandma and my mom are coming to visit. My granny, that's what I call her. They're coming from Louisiana. I was really nervous that the hurricane was going to make their flights canceled. But they're coming to visit me on Thursday and they'll probably be here through like Monday. So I don't know if I'm going to necessarily be recording any lives on those days. I will have Through the Storm Thursday coming on Thursday and we will be doing that premiere. But should I go live tomorrow? What do y'all think? Thank you, Sydney. Thank you, Mel. When money is involved, always go to the IRS because surely tax fraud would be involved there. Oh, yeah. Maybe I'll go to the IRS. We'll see. Please take care of yourself. Girl, we need your expertise. Colin. Go live. So tomorrow. I'll just go live tomorrow then. Oh, wait. Oh, also, I'm going to be live tomorrow already with Sloan on his channel at 4 o'clock. We're going to be talking about like Jason Alexander, like he went live today. I don't know if y'all saw that. And there's some news stories out about him. We're going to be talking about this filing, which like we won't be going line by line. I don't even know if this document will be pulled up. Like this is the Deep Cuts channel over here. But I'm going to be going live with Sloan tomorrow anyway, but maybe I'll go live with that email from the Department of Justice and the complaint and stuff tomorrow and just like hang out with y'all. I am going to have a day off, Sharon, from like Thursday to Monday because my family is going to be here for my birthday. So I'm going to have some days off. That's what I'm saying. Should I just like do a live tomorrow? Yeah, that's what I'll do. Okay. So there's a 100% chance. Well, okay, listen, you can't say 100. There's a 99.999 barring any unforeseen circumstances chance. I will be going live with Sloan tomorrow and we'll be live on Sloan's YouTube channel. And there's like a pretty good chance that I'll also go live, at least with that DOJ thing. But thank y'all so much for hanging out. Thank you so much again, Julie. Thank you so much again, everyone who gave, donations. It really does. It's not the reason I do this, but it helps a lot. Like, it makes it a lot easier to click that, like, purchase the document button, because it's like, that's just so nice that y'all, it's like a community and we're kind of contributing. Yeah, the book club is still going to be going on. No, I don't think that YouTube can take the channel off for reading a copyright book, because it's actually considered commentary and it's protected under the Constitution. And if YouTube were to do that, then I would probably have my good friend Christopher Melcher help me to file a federal case of constitutional violations, because it's, the copyright that they have is not to the sounds. The copyright they have is to the words on the page. So if I were typing the words on the page and distributing them, that would be the copyright issue, because it's taken away their ability to like make money off of it. But because I'm stopping to comment on it, it's actually protect. Oh, my Roberts, stop. You have reminded me that as an American citizen, I have rights that I need to hold with a certain standard and respect. And I think Brittany's case has reminded a lot of people of that fact. Exactly. And there's also a channel. I don't know what I can only watch it for so long, but my partner watches it all the time. It's this Instagram account where it's basically these people that like go into police stations and like traffic stops and stuff, and they basically assert their constitutional rights against the police. And the police are like, you have 5 seconds to stop recording me or I'm gonna blah blah blah. And they're like, actually, sir, and they're like recording them. Actually, officer, you're mistaken. You're on public property, and they're very calm and very like, not like me about it, but they're like schooling these cops. And then they'll be like, can I talk to your supervisor? And the supervisor will come and also not know. Like, I saw them like tear up this FBI supervisor the other day. And it's like, every time at the end of the video, it's like they won, because like my Robert 626 just said, a lot of people kind of like, we just kind of get used to letting the cops and the government and the courts and the judges just treat us any kind of way. And we forget, like, wait a freaking second. This is a democracy. This is we got rights over here, and y'all are our employees. You are a public servant. You work for me. You work to protect my rights, not to take them away. And so it is this, like, I think Brittany's case has really made a lot of people wake up to, like, you can't just close your eyes to what's going on in our institutions, because these people are either incompetent or they have absolute, oh, the unicorn. Unicorns are my favorite. Thank you, Gabby. Oh, thank you. Because these people are incompetent sometimes and actually corrupt other times. So completely agree with you. My Robert 626, it really brings home, like, you can learn about all these concepts in civics or law school if you've gone, or even just on the news or whatever. You can learn about these concepts in the abstract, but it's kind of cool because we can kind of take this and apply it to our own democracy and say, no, we're not going to stand for this. We have rights and they have to be respected, right? We have to hold with a certain standard and respect. And like you said, Brittany's case has reminded a lot of people of that fact. Okay, I am actually going to go now, but it was really great to hang out with y'all. I really, really enjoy doing these lives. I know that y'all don't like when I stop and read comments that much, but it is really fun to me. So please just bear with me, because I really like to read them sometimes, but I am trying to limit it and stuff like that. But I will be live on Sloan's channel tomorrow, 4:00. We're definitely doing Through the Storm Thursdays. People are telling me their notification bells aren't working. I really don't know how YouTube works and stuff like that. But I will be on YouTube for those two things. So you can plan on